The Committee on Appropriations and Adjudication calls this public hearing back to order. It is now 5 minutes after 3 p.m. on Thursday, November 1st, 2018. For this segment of the hearing, we will be hearing the following bills. Bill number 32-34 COR, relative to tuitions and fees. Bill number 362-34, introduced by myself, relative to continuous appropriations of the Chamorro Land Trust Survey and Infrastructure Fund revenues. Bill number 350-34, introduced by Senator Dennis G. Rodriguez, relative to approving an amendment to an existing license agreement with the Chamorro Land Trust. And Bill number 335-34, bill introduced by Senator William M. Castro, relative to cooperative agreements with one or more regional partners to share or consolidate services for medical referral assistance offices. So we'll start with Bill 32-34, and I'll ask the sponsor to give an overview of the bill.
Thank you, Mr. Chair. Bill number 32-34, an act to amend Section 28202A and 28202C of Article 2, Chapter 28 of Title 17, Guam Code Annotated, relative to the tuition and fee benefit for merit award recipients under the Student Financial Assistance Program for Higher Education. Sir, ladies and gentlemen, the bill will allow monies under the Merit Recipient Program to spread out further and benefit more students under the Merit Recipient Program at the University of Guam. Students who receive Merit Recipient Program and then is approved under the federal Pell Grant will utilize the Pell Grant instead. First, the Merit Recipient monies will then revert to the Merit Program and made available for other Merit Recipient students and other scholarships. That's the intent of this bill. Thank you, Mr. Chairman.
Thank you. Signing up to provide testimony is Mr. Mark Duarte, Dr. Anita Enriquez, Mr. Robert okay, Dr. Kreis, and Mr. Al Labang. Okay, so you can all come forward and to the table. Oh, Dr. Robert Underwood. I saw Robert, but I didn't see Underwood. It was kind of okay. So, if I may, I would like to defer to Dr. Kreis to go ahead and open up.
Thank you, Senators. I'd like to defer to the Senior Vice President for Academic and Student Affairs because she's more expert in it, but just to say that this bill would put the University of Guam in the position of most other institutions of higher education that expend federal funds before local funds. So I'd just like to say that that's the gist of it, and I'll ask Dr. Enriquez to elaborate.
Yeah, thank you. Dr. Enriquez?
Yes. Mr. Chairman, I'd like to defer to our past president, Dr. Robert Underwood, who has a schedule, and so I'd like to defer to him at this time. Thank you.
Okay. Dr. Underwood.
Well, thank you, Senator, and thank you, Dr. Kreis and Dr. Enriquez. And, the only reason why I'm here testifying is because I had asked for this bill in this legislature. And
so if you can speak closer into the mic.
Sure. This bill basically corrects a practice that has been ongoing for a while, and that is that when a scholarship recipient, the intent of the merit scholar is to give the recipient from local money the full tuition and fees, a book allowance, and a stipend. And so that commitment is worth about, a little over $40,000 if someone goes to the university for the full 4 years. And what happens is that through an anomaly, if they're eligible for federal funds, they collect the federal funds too, which actually the government of Guam ends up supporting the federal government side of it. And so this bill allows that if someone is eligible for federal financial assistance, that be tapped in first, and then the government of Guam, through the Student Financial Aid Program, will make up the balance. This will make all scholarship recipients from all scholarships at the university be treated the same way for these purposes. It would also free up a little bit money so that the scholarships can be distributed to more people. And that's basically all it does. I think it's a good faith measure, and I think it just balances it out. And it was an anomaly that we witnessed for a few years, and so now we corrected it in all the other scholarship programs that are authorized by the Guam legislature. And so we're asking, or the university is asking, that it be corrected for the merit scholarship. Thank you very much.
Thank you very much. So, Dr. Enriquez, did you want to pick up from there?
Yes. Buenas Day, Mr. Chairman, Madam Speaker, Mr. Chairman San Agustin, Senator Castro. Thank you for the opportunity to provide testimony on Bill 3234. We are providing both written and oral testimony in support of this legislation. As you are aware, the Student Financial Assistance Program, or SFAP, is currently administered by the University of Guam. SFAP over the past few decades has proven to be invaluable to our local students. I myself have been a former Merit Scholar awardee. We believe that the change proposed in Bill 3234 will help the long-term sustainability of the program, as well as allow more students to benefit from SFAP. The Merit Award, which is the main focus of this legislation, is just one of many programs under SFAP. This award is provided to our highest scholastic achievers from public and private high schools on Guam, including DODEA. The program offers a full scholarship for tuition and fees to attend UOG or GCC, a monthly stipend, and a book stipend at the beginning of each semester. For the 2017 academic year, there were 215 students in the Merit Award program with total expenditures of $2,420,713. For the 2018 academic year, as of the Fanutsanan, or fall 2018 semester, we have a total of 216 Merit Award students. We estimate expenditure levels similar to the previous academic year. If Bill 3234 is successfully passed into law, we are anticipating significant savings in the Merit Award program. This is possible because the law would make the Merit Award a last dollar award, a type of awarding method favored by most state governments in that it leverages federal funds first prior to utilizing local funds. Consider this hypothetical example of a last dollar award calculation. A Merit Award student with a zero expected family contribution, or EFC, qualifies for a maximum Pell Grant award of $6,095 for the 2018 to 2019 academic year. If she enrolls at the University of Guam with tuition and fees of $5,804 per year, her Pell Grant award will cover all of her tuition and fees, and funds not expended from the Merit Award program could be reinvested into the SFAP programs to assist even more students. I apologize, there should be an S at the end. In this second hypothetical example, a Merit Award student qualifies for the Pell Grant but has a higher expected family contribution of $2,000. Based on the federal Pell Grant award guidelines, her maximum Pell Grant award for the academic year would be $4,145. If she enrolls at the University of Guam with tuition and fees of $5,804 per year, the Merit Award will cover her tuition and fees up to $4,145, and the Merit Award Program would pay the remaining balance of $1,659. A savings to the Merit Award Program of $4,145, which again could be reinvested into other SFAP programs to assist even more students. Of the 216 students in the Merit Award Program for this academic year, 83 students are eligible for the Pell Grant. Based on our calculations, those students are entitled to $364,492 in Pell Grants, the same potential savings to SFAP if this legislation was in effect. We think there is the potential to save even more money. 96 of the current Merit Award recipients do not have a FAFSA on file. We are unable to determine their eligibility for the Pell Grant because they have not filed a FAFSA with the federal government. We suspect that a significant percentage of those students may qualify for the grant and reduce the amount expended from the program even further. The university awards Pell Grants to approximately 2,245 of its undergraduate students, which is 63% of the student enrollment. Bill 3234 would allow SFAP to service a greater number of students with the savings from the Merit Award Program. In closing, the University of Guam supports the passage of Bill 3234. The savings resulting from the legislation, through your support, will be reinvested into SFAP and will be used to offer more awards to a greater number of students. Masi.
Thank you, Dr. Enriquez. Mr. Duarte?
Thank you very much. I'm here just to offer as a resource from the university regarding the Merit Award. And I think our student is here to provide additional testimony as well.
Okay.
Honorable Senators of the 34th Guam Legislature, I am Aldabang. I'm a current student at the University of Guam and a current member of the 31st Guam Youth Congress. I came here as a student of the University of Guam and stand in support of Bill 32-34 that would make merit scholars who are eligible to receive federal Pell Grant to apply the Pell Grant they're receiving to their tuition, and the remaining will be covered by the SPAF. As a student, I believe with the passage of this bill, it would open more opportunity to the students that rely on other financial aid programs that's under SPAF. Beyond that, it will pave the way to allow more students to go to college and seek a degree. With the funds being saved, it will be beneficial for not only the university, but also for the students that need the financial aid. Beyond that, I think it will open more programs for other students who need financial aid as well. That's all.
Thank you very much for your testimony. Senator San Agustin, do you have any questions?
No, Mr. Chairman. Thank you.
And I also, for the record, want to recognize the presence of Senator Nelson and Acting Speaker Therese Terlahi. Senator Castro, do you have any questions? Senator Nelson? Speaker?
Yes. Dr. Enriquez, you said that there might be an additional potential to save money because you don't even know at this point how many people might be eligible for FAFSA or the Pell Grant. Okay, so, but the bill doesn't mandate that they even apply for that, does it? Or does your office, it seems to me like we would have to also require them to either apply for that Pell Grant or, to achieve those additional potential savings. Is that correct?
Yes. Thank you, Madam Speaker. Yes, for clarification, currently the law does not require them to do so. All the other awards under SFAP give us that flexibility to require students to pursue the FAFSA Pell Grant opportunity. This award is the only one that does not require them to do so because it is something very expressly stipulated as public law, and it doesn't give the university that flexibility.
All right, I was just wondering if students maybe don't apply. Well, obviously they feel like they don't need to apply if they're just going to go with their merit scholarship. And would this have the opposite effect, perhaps, if we made it mandatory that they had to apply for that? That they would, no, I guess it wouldn't. I don't know. I don't know. What's your experience?
Right.
Yeah.
It would not disadvantage them from receiving the benefit of the full merit award intent. Currently, as the law is written, they do not have to apply for FAFSA to receive that particular benefit. Because that award is carved out of the SFAP fund, which is a locally appropriated fund, it shortchanges the opportunity to be able to take advantage of the federal subsidy under FAFSA, under the Pell Grant program. And by requiring the students to take advantage of what they would otherwise qualify for, then it frees up a certain percentage of the SFAP fund in order to benefit a much larger percentage of students who otherwise are not eligible for a merit award.
Okay, well, I don't know if that's something to be addressed in a separate bill, but if you are requesting that, then please, yeah, make that clear to us, that you are requesting that that be added to the law, that they would be required to apply for a Pell Grant.
Okay.
And technically, Madam Speaker, is that the law also allows the university to create its rules and regs.
Oh.
We can include that in the rules and regulations to
Oh, so
allow
you've
them
had that
to,
option to
yes.
require it? Okay, then.
Yeah,
I
we
will
can do it
just-
in
We don't
rules
have to
and
weigh
regs
in on that.
or in the
That's
law.
up to you. Okay, great. All right, thank you.
It's not here. I don't have it. It gives a summary of what the bill is about. Did you have any more questions, Speaker? No. Okay. All right. Well, then, if you have any closing comments, Senator San-Agustin?
No, Mr. Chairman, I think the testimony provided is sufficient for the bill.
Okay, great. Excellent. So with that, then, we'll consider Bill 32-34 as having been duly heard. Thank you very much.
Masi.
Hagamas. Next, we have Bill 362-34, which is an act to amend 75-124 of Chapter 75, Title 21 Guam Code Annotated, to continuously appropriate Chamorro Land Trust Survey and Infrastructure Fund revenues. Mr. Michael Borja.
Good afternoon, Mr. Chairman, Senators. My name is Michael Borja, the Administrative Director of the Chamorro Land Trust Commission, and the testimony that we submitted is submitted from the Chairwoman Pika Feharan, who is unable to attend this afternoon. So I'll just read what our testimony is. On Bill number 362-34, it seeks to ensure the revenue collected from the Chamorro Land Trust Survey and Infrastructure Fund is used as it is intended and not transferred into the general fund for uses not intended for the Chamorro Land Trust Commission. The COTC Board of Commissioners have not yet had the opportunity to formally comment on this bill. However, the board was fully aware and dismayed by the fiscal year 2017 financial audit report indicating the need to write off $321,262 in revenues intended for this Survey Infrastructure Fund because it was diverted to the general fund. In accordance with the Government Auditing Standards Board Rule number 34, funds categorized as an interagency loan with no feasible means to repay the intended account within a reasonable time must be recorded and recognized as a permanent transfer of funds. This bill would preserve the revenues intended for the CLTC Infrastructure Fund. It provides further guidance on the process for approving expenditures, the types of authorized expenditures, reporting of collections and expenditures, and an audit requirement. The cost to conduct surveys or infrastructure development are high. This bill is a major step towards protecting the fund, so it is used to improve the Chamorro Land Trust homelands. Surveying of properties has been and continues to be a financial burden to the Commission's lessees, and that they've had to endure, resulting in many leased properties still not surveyed. Infrastructure development is no small matter, which would require significant capital to undergo a cost-efficient program. In either case, draining the fund stagnates the ability of the Commission to engage in improvement of homelands that the lessee may benefit. While this bill does not provide similar protection to other CLTC funds, the CLTC's 27 financial audit further noted an additional write-off of $320,105 from a permanent transfer of funds from the Loan Guarantee Fund to the General Fund. This fund transfer became classified as uncollectible loan, thus requiring the write-off in accordance with GASB Rule Number 34. Cash revenues collected by the Chamorro Land Trust Commission for its needs should be locked from these types of transfers, and we humbly ask that this bill also include such language. The Loan Guarantee Fund provides the necessary assurance from the Commission for a lessee's home loan lender because the land cannot be mortgaged. Taking these fund limits to the Commission's ability, or taking these funds limits the Commission's ability to provide loan guarantees to the lessees. We thank you for the opportunity for allowing us to provide this testimony.
Thank you, Mr. Borja. Now, the reason why this bill was introduced was because there was that $300,000+ that was transferred out of the Survey and Infrastructure Fund, and because those funds were identified as unappropriated funds. And the law, the way the law reads is that before it can be expended, the legislature has to appropriate those funds. So basically, then what the bill does is it will, whatever funds get put in there will then be deemed to be appropriated and can then be immediately used by the Commission for the purposes that have been set out in the law, surveying, putting in infrastructure, etc. Hopefully this will protect those funds a little bit more than we thought. The language of not subject to the transfer of the governor. We'll see. So then we'll take a look at the recommendation of how to protect the funds in the home loan account. We'll see if we can address that also. Speaker, do you have any questions?
I know that the law already says that the fund shall not be subject to the transfer authority of the Government of Guam, and the governor, but I know that we recently passed a law regarding the child support fund that added an additional language, I think even on top of this. I can't remember what that language was though, on top, and I guess that's what you're proposing, that we add that in for all the Chamorro Land Trust funds?
Well, the ones that do get revenues from
Yes.
different sources, like
Dedicated, yes.
Yeah.
That was what I wanted to know. Has the Commission, although they had to write it off for audit purposes, have they pursued these funds from the Government of Guam?
No, because the auditors told us that they're unpursuable.
They're what?
They're not. We will not be able to get it back. That's the reason the write-off has had to occur.
Is that the advice you got from the Attorney General's office also?
That was the advice we got from from the auditor, the independent auditor.
Could you, I guess, just pursue that with the Attorney General's office and let us know if with this language in the statute they are unable to do anything to attempt to, or to, as a result of, the money being taken despite the law saying it shall not be subject to transfer? Thanks.
Okay.
Okay, thank you. All right, Senator San Agustin.
Mr. Chairman, it's just kind of like a follow-on question, reference to what Speaker July brought up. Is there any way we can, maybe the bill can be amended that it's non-transferable and is prosecutable if transferred? Is this something to add on to it to protect the money? Because I can imagine the Tomorrowland Trust is just trying to get the little money they get and do what they need to do. And if it keeps allowing just that shall not transfer, but there's nothing in the law that actually places the Attorney General to get involved and say that if you take the money, the Attorney Generals can come after you, regardless of which governor it is. It's just that I'm just trying to find a way where we can find some added words to protect the money. That's the only thing I wanted to ask you, Mr. Chairman. Thank you.
Thank you, Senator San Agustin. Senator Castro, did you have? Senator Rodriguez, did you have any? None? Okay, fine. Well, I don't have any further questions or comments on the bill. So if there being no further questions, I will consider Bill 362-34 as having been duly heard. Thank you very much. Next up is Bill 350-34, introduced by Senator Dennis Rodriguez, and I'll go ahead and I'll ask the sponsor of the bill to introduce, give an overview of the bill.
Thank you very much, Mr. Chairman. Thank you for everyone for being here. Bill 350, Mr. Chairman, is relative to approving an amendment to an existing license agreement with the Chamorro Land Trust Commission and to provide an annual continuing appropriation from the Recycling Revolving Fund to provide payment for a prior year obligation resulting from a 2001 license agreement executed by CLTC for 25,000 metric tons of metallic waste removal from the island of Guam. Mr. Chairman, I want to thank you for having this hearing today. This is a continuation of a previous bill that was introduced by Senator San Agustin and myself. We understand that there was some issues with that bill, and so we've made changes to that. And so we're now here entertaining this piece of measure. Thank you, Mr. Chair.
Thank you, Senator. Signing up to provide testimony, oral testimony, are Attorney Carlos Baldon, Mayor Rudy Matanani, Nicholas Lee, and I believe Mayor Hoffman. You want it also? Oh, and Mike Borja. So I'm going to go ahead and ask to defer to Mayor Hoffman. He has a 3:45 commitment that he needs to meet. So go ahead, Mayor Hoffman.
Thank you, Senator. I actually have to take my daughter to dance. I have to be a dad at the same time.
That's important. That's important.
Thank you. Let me just begin by saying thank you, Chairman Atta. Buenas and Hafade. We're pleased to submit testimony in full support of Bill 350-34, sponsored by Senators Rodriguez and San Agustin. I join my colleagues in supporting this measure because the Mayor's Council of Guam is keen to resolve this issue of the debt owed to cocoa recycling. This is why the Mayor's Council unanimously passed Resolution 2018-16-003 on August 1st. As you know, the mayors and vice mayors of Guam have been working on village cleanups and recycling with many other Guam-based recycling companies and permitted heavy equipment companies. And if the debt owed to cocoa is not resolved, we strongly feel there'll be credibility issues with these other companies now and in the future. To simply put it, when one agency or department fails to pay a vendor, the rest of us suffer because that vendor no longer wants to do business with the government. This leads to higher costs and difficulties in procurement. This has happened to us for all types of companies, either because of the lack of payment or from untimely payments from agencies and departments. While the agreement took place took place before I was in office, several mayors who were already duly elected and serving in office can attest to fact that these cleanups did take place. We hope that in the spirit of cooperation and willingness, you'll be able to resolve and correct this 17-year-old debt. And I want to commend the administration for working with the legislature to also get this done. I think this is something that we all want to see put together. I understand there's concerns about certain issues with it, but I think as a vendor, working with the vendors, especially this last cleanup, they're talking about it. So this is something we want to see if it can get resolved. Thank you.
Thank you very much, Mayor Hoffman. Mayor Matanani, did you want to? Okay, please. Okay, turn on the mic. Please bring the mic close to you, okay?
Okay. Thank you, Honorable Senators, for taking the time to listen to testimony in favor of Bill 350. I've known about this maybe 14 years ago when cocoa recycling was working on the project, somewhere around there. And I don't want the reputation for the Mayor's Council, to be spread out that a company like this is helping us clean the beautiful island of Guam, and most especially the village of Jigo that has a lot of problems there as far as illegal dumping and illegal car parking because people can't afford getting rid of their junks. And I want to thank all of you for bringing this to pretty close to a closure and helping cocoa recycling to get this bill resolved, because yes, I don't like repeating things that have been said already, but it would give us a bad reputation when we go out and seek for help from recycling companies or companies to help us clean our island, and we get this thing about not helping cocoa recycling getting paid for a job well done. So, on behalf of the Mayor's Council, the 19 mayors and the 7 vice mayors, we support this bill, that we do the right thing and pay the bill. Thank you very much, Honorable Senators, for listening to this simple testimony that I hope will get somewhere. God bless.
Thank you very much, Mayor Matanani. I noticed the chairman for the Guam EPA is here. Do you want to provide testimony also? Okay, fine. All right. I'm going to go ahead then and go with the chair, the executive director for the Chamorro Land Trust.
Again, thank you very much, Mr. Chairman and Senators. The testimony we are submitting is from the chairwoman, Ms. Pika Ferharan. Bill 350 intends to amend the Chamorro Land Trust Commission license agreement with cocoa recycling to grant them an appropriation for the removal of metallic waste, as well as credit from the CLTC to offset rental payments. The purpose of this license agreement with CLTC and cocoa recycling was to manage and remove solid waste, tires, batteries, ferrous and non-ferrous metals, paper, glass, and other recyclable materials from the CLTC properties, but specifically from Lot 10122-15 in the municipality of Dedido. The license commenced on July 1st, 2001, and was supposed to be for at 5-year intervals for 20 years. Compensation was determined to be 1% of the fair market value and set the monthly rental to be $6,631.20. Rental fee, however, could be offset by a credit for cleanup of CLTC property at a rate of $20 per cubic yard. The agreement was for the cleanup of existing metallic solid waste on CLTC property. During the course of the term of this agreement, a significant amount of external solid waste from subsequent typhoon damage was delivered for removal. This debris was from throughout the community that caused cleanup amounts to greatly exceed the projected activity, as cocoa recycling served a much needed service to the community as a whole. While the amount of solid waste removal and disposal service conducted by cocoa recycling during this period is very credible, CLTC does not possess the actual documentation for all the services performed. In October 2011, Cocoa Recycling approached CLTC at a regularly scheduled board meeting to request an amendment to the license agreement, seeking a change in the compensation to recognize the amount of removed solid waste. The Board of Commissioners, pending documentation, did not act on the amendment. Based on the monthly rental fee for the full term of the license agreement, Cocoa Recycling owes the Chamorro Land Trust Commission $1,591,488. This is the only amount considered acceptable as a credit in exchange for a rental payment as permitted in the license agreement. Additionally, the following items are of concern in the bill. Page 4, line 9, item number 2, pursuant to Section 2 term of the license agreement, the parties agree that the initial term of the license agreement shall be deemed to have commenced on September 4th, 2005. Excuse me. Clearly, the opening line of the license agreement states the effective date is July 1, 2001, while Part 2 of the term states that the term of this agreement commencing within 2 years of the date of the execution of the contract. There is no date with the executing signatures, and the only date is placed by the notary. The Commission contends that the commencement date is based on 2 years from the effective date as of July 1, 2001, as shown in the opening line of the first page of the license agreement. The title of the bill also expresses the agreement execution is in 2001. Therefore, the commence date should be July 1, 2003. Number 2, on page 5, line 12, item number 4, the licensee shall be authorized to conduct the following business activities on real property of Lot 5219-1-1 in Barragata: solid waste processing, solid waste management, disposal and recycling, hard fill, storage, warehousing, operation of construction office, and storage and sales of construction and building materials and equipment, and a laydown yard. Our comments on this is that the inclusion of additional activities to this license agreement, such as construction office and storage and sales of construction and building materials, and this laydown yard, was never the intended purpose for this agreement, nor has it ever been a discussion item presented to the Board of Commissioners, and should not be included in this bill. Number 3, on page 6, line 2, item number 6, CLTC and the licensee may negotiate for the exchange of another property in substitution of the property licensed herein, and any such substitution must be mutually agreed by the parties. In the event that these parties agree to the substitution of another property, the credit currently due to the licensee shall be transferable to such property. Our comments on this is that with the limited time remaining on the existing term of the license agreement, and based on its purpose as a waste processing facility, it is not in the best interest of the CLTC to exchange or substitute the licensed property. The licensee should devote the remaining term of this agreement the property to an acceptable and usable condition. And then our 4th issue on the bill, page 6, line 12, item A, statutory creation of the CLTC credit. There is hereby established a CLTC credit of $1.6 million to be used by the licensee in lieu of cash payments to CLTC, and in order to satisfy the terms and conditions of this subsection, such CLTC credits established herein shall not be assignable to a third party or parties, and shall only be used by the licensee against any real payments that would otherwise be due the licensor under the amended license agreement. Furthermore, such CLTC credits established herein shall remain valid and lawfully binding until the fully redeemed pursuant to this act, and shall be honored by the CLTC accordingly. Our comments to this section of the bill is that the specific rent credit should be authorized should be the exact amount which covers the period of July 1, 2003 to June 30, 2023, which is $1,591,488. Likewise, CLTC will not and should not be held liable for any other costs or expenses regarding this license agreement. The credit is not a form of currency to be granted to the licensee, but rather an authorized accounting credit to a receivable on a monthly rental fee, past, present, and future. Any unused portions of this credit shall be deemed null and expressed accordingly, and in no way shall this credit be expressed as an assignment, nor shall it be ever assignable towards another interest, such as another licensee or property. And those are our comments regarding this bill.
Thank you very much, Mr. Borja. Attorney Spaldon.
Thank you, Mr. Chair, and good afternoon and to you and to the members of the committee. I'm here today to present testimony on behalf of the Office of the Attorney General. I will present oral testimony, and I will follow up my testimony with written statement for the record. Members of the committee, the Office of the Attorney General has serious concerns with Bill number 350-34, and we strongly oppose its passage. Bill number 350, Section 2, would statutorily approve an amendment to a 2001 license agreement between the Chamorro Land Trust Commission and Cocoa Recycling Corporation. In addition to statutorily mandating the CLTC to execute the amendment, the bill dictates the specific language, including the terms and conditions of the amendment itself. In our opinion, this attempt to legislatively approve a contract amendment whose terms and conditions are set by the legislature itself is a clear violation of the separation of powers doctrine and is therefore inorganic. The Supreme Court of Guam has ruled clearly and definitively that the legislature may not dictate the terms of a contract, in this case, an amendment to the 2001 license agreement. In re Request of Gutierrez, a 2002 Guam Supreme Court case, at issue were provisions of a budget bill that dictated the terms of a government lease. In that case, the Supreme Court found a, quote, egregious violation of the separation of powers doctrine, unquote. In finding this egregious violation, the Supreme Court stated, in the instant case, the legislature has not merely reserved for itself the power to give advice on the specifics of the contract. Rather, the legislature has dictated the exact terms of the contract. It is the executive's function to determine how to execute a contract. The execution of a contract necessarily includes determining the terms of the contract. By determining the terms of the lease, the legislature has engaged in a clear executive function. This Guam Supreme Court case appears to be directly on point with respect to what Bill number 350 is attempting to do. And interestingly, in the Gutierrez opinion, the legislature was setting the terms of a lease that had yet to be procured. Here in Bill 350, not only is this legislature setting the actual terms of the amendment, it is statutorily approving it as well by legislative fiat, and we do not believe that is acceptable. Our next point is that we wanted to bring to your attention is that we note in Section 3 of the bill, the legislature makes annual appropriations of $590,000 out of the recycling revolving fund for 10 consecutive years to fund prior year obligations that would be established through the amendment to the license agreement. This provision raised some questions to us given the legislature's function and duty to make annual appropriations for the government, usually through the Appropriations Acts for the coming fiscal year and based upon the projected revenues for that fiscal year. We further remind the legislature that it is commonly understood by all courts that have considered the question that one legislature cannot bind future legislatures, which means that successive legislatures may repeal, amend, modify, or suspend any actions, including these continuing appropriations, by future legislation. That's all that the points that we have today, Mr. Chairman, but I think that the first point that we raised was, in our opinion, dispositive in terms of how we feel and why we oppose this bill as drafted. So therefore, we reiterate our opposition to Bill 350, and I'm available to answer any questions.
Thank you very much. And do we have a copy of your written testimony?
We do not. I'm going to finalize it, Mr. Chair, because I just finished it before I came over here, and I will submit a copy to you.
Okay, thank you very much. And then finally, on the list to provide, I also should note that we did receive testimony from the written testimony from the compiler of laws, and is in opposition to the bill but from the standpoint regarding the concern that the compiler of laws has regarding the codification of the proposed language into the Guam Code Annotated, otherwise takes no position on the purpose of the bill. And we also have received testimony in support of by the attorney for cocoa recycling, Attorney Fred Horecki, who is not able to be present today because he is off island. So the final individual signing up was Mr. Nicholas Lee from the Guam EPA.
Hafne, thank you, Mr. Chair, and Hafne to the members of the committee. It is the agency's understanding that the Chamorro Land Trust Commission and the Department of Land Management may compromise their revenue streams should the amount of the waste removal be leveraged against the original license agreement for land use credits in lieu of rental payments. After careful review, it would appear that this bill contains enough of a legal framework to provide an alternative means for final compensation on a 15-year-old debt in reference to services that remove some 25,000 metric tons of waste from our island. In the spirit of intergovernmental cooperation, the agency supports this measure, but with the understanding that every reasonable avenue to satisfy the debt has been fully exhausted, and with the understanding that no provisions of local government law are compromised. This concludes my testimony. Thank you.
Thank you very much, Mr. Lee. Senator Rodriguez, do you have any questions?
Thank you very much, Mr. Chairman. And thank you very much for your testimonies, Mr. Espaldon. Mr. Borja, when we first introduced this bill, this was earlier, I believe last year, Bill 228. This was the first version of this effort to resolve a long-standing issue between the government and cocoa recycling. It was brought to me, it was brought to my attention by I don't know if it's you personally, we're going to have to go back and check this out, that legislative remedy was required. And that when we drafted the piece of legislation, it went through CLTC, and that it was determined that we had to do it this way. Can you answer that first question?
We don't have that kind of authority in the CLTC to just amend the contract, and especially when it comes to what this whole effort was about, was to satisfy a monetary claim of $7.5 million. There was just no way that the Chamorro Land Trust was willing to take on anything greater than what it had agreed to in the contract, which was the $1.5 some million. And that's what we looked at. I mean, that's what we thought we had to do. Obviously, amending or codifying the sections of the Guam Code is an issue with the compiler, and obviously the Attorney General's office also has issues with that.
But I think with the Attorney General's, at least his initial testimony was that this is inorganic. Having the legislature amend it and approve it this way is inorganic. And that was the direction, that was what we got recommendation from you, or I don't know if it's you personally, but it was from your office, that we needed to do it this way. And so that's why I don't know if you had counsel from the Attorney General's office and that cleared through them, because we wouldn't be in this situation if it did go through that process.
Don't have any other answer to that.
Okay, so Mr. Espaldon, I don't know if who in the Attorney General's office is assigned to their office, but someone has got to do a check on this, because it was under my impression when this was presented to me that legislative action needed to be taken. And that's why we introduced Bill 228. It's pretty similar to what we have here before us now. There was some concerns raised by the committee at that time, and we made the changes needed. That's why we reintroduced the bill, because of I believe, with the appropriations that we included here from the recycling revolving fund. And so I'm fine to take a step backwards here and to see exactly where we're at, but no doubt that this is an issue that we must resolve. Our mayors acknowledge this. This is work that's been done many, many years ago, and the government has an obligation to resolve this. And so if there's technical issues, or as you say, it may be inorganic, of course we have to resolve that, but I think we all got to get on the same page here. I was under the impression that CLTC, land management, EPA, the governor's office who was involved with this, that everyone was on the same page and what we were doing here needed to be done. And so, Mr. Chairman, I'm requesting that, perhaps that we take a step back with this and that we get them to get us all on the same page, because the bottom line here is that this has to be resolved. This long-standing debt to cocoa recycling must be resolved one way or the other.
Anybody else have a question? I do have a question of EPA. So what is EPA's position with regards to the use of the recycling fund? That is EPA's support of the bill then suggesting that the use of these funds, it's okay to use it to pay prior debts as opposed to using it for the purpose of cleaning up our community?
Since the 2015 OPA report on the recycling fund was issued, this called for a moratorium on spending out of the fund, except for whatever was set in 10 GCA 51, I believe.
And what was that?
So there's an outreach and education contract. There's a salary and benefits for a recycling officer, and the economic stimulus program for the recycling industry. I think that was passed in the 33rd. So currently, those are the only things that the fund is being used for, with the exception of last fiscal year when the legislature appropriated some $2.2 million to the Mayor's Council for an island-wide cleanup program. So we've been very careful on how the fund is managed and how it's used. And so I guess to answer your question, if this becomes law, then we will comply with it because the law says we have the money to pay the prior year obligation. Now, I'm not sure how that's defined, and I think the bill references a contract that was issued by GSA prior to the exchange of the fund from DPW to Guam EPA about 10 years ago. So,
right. So my question is it then EPA's position that that now we're adding an additional use to the funds aside from the outreach, the cleanup programs, now to add an additional function of paying prior debts? Is that EPA's position that it's okay that we use that? And I ask that because I don't see language in here that says, notwithstanding what the law authorizes for the use of those funds, now we are, in addition to that, we're now going to use it to pay prior year's debts. So it appears that EPA's testimony is that now we can pay prior year's debt in addition to everything else. And is that what was intended by EPA?
I'm not going to support other prior year debt, but I'm assuming some precedents might be set by doing this.
Yeah, but so I guess my point is that it's probably not EPA's responsibility about taking care of prior year's debt. It seems that EPA's responsibility is keeping our environment clean with the funds that's provided to you. So,
and we will support that.
Right. Okay. All right. Does anybody have any?
Mr. Chair, I got a follow up to that, if I may.
Sure.
Okay. So, sir, you just answered that that you believe that that the fund should be used for making sure our environment is clean, right? I mean, just to kind of paraphrase what you answered the chairman.
Sure, I can agree to that.
But you did say you don't support it if it's for prior years?
Well, the agency is also in the process of trying to get our rules and regulations adopted for use of the fund. That's also stipulated in statute.
I guess let me ask this: do you acknowledge the work that was done by Cocoa Recycling?
Yes, we do.
The cleanup that was done?
And that is waste that we'll never have to deal with on the island ever again. So
okay, so
yes,
if you
we acknowledge
that, and there was no payment made to them, you won't support that what we're trying to do here to pay for prior year's work?
If there's a guarantee that this is done properly, we will absolutely support it. And from our review,
If what was done properly?
if the legislation is done properly, and from our review, it appears that way, so we support it.
Okay, I just wanted to get on a record because I kind of heard something different from the answer you gave to the chairman.
No, my apologies.
Thank you very much.
I have something to say here. You know, the mayors and the vice mayors have a big stake in this problem. So, you know, I was just told that our consul is the Attorney General. So I want to ask the Attorney General to intervene here and advise us on how to go about and, you know, getting this payment paid, because this is not the right thing. No, sir. So, you know, I'm asking you in public.
Well, I don't think
Can I do that?
I don't think this is the appropriate time to ask the Attorney General to make that.
Okay, then I'll do it in private. But
Well,
you know,
I mean, certainly the Mayor's Council can you know,
but
write to the Attorney General's office and request for that. But I don't think this is the forum.
Okay, that's fine. I didn't mean any.
No, I know you did not.
I didn't, because, you know, I'm just trying to help everybody here, because, you know, it's us that's, you know, the people that are asking help, you know, and like I said, our reputation is, you know, to work with recycling companies and other companies that help us with our responsibilities, and we need to find a way in fixing this problem.
I understand, Mr. Mayor.
Thank you.
Okay. Any senators have? Okay. Speaker.
Thank you. I had a couple questions. First of all, for EPA, since the last fiscal year 2018's budget, we appropriated, like you said, $2 million from the Recycling Revolving Fund, right? That's the same fund that's, according to this bill, you want to use to pay prior years, as opposed to, would we be able to do both with that fund? Pay $2 million to the mayors to do current cleanup in their communities, like what they're doing right now after the storms, or is that fund limited? So if they took the $500,000 a year out of that fund to pay for these prior year obligations, what would be the impact on the current projects for the mayors?
Thank you for the question. To be honest, I couldn't tell you. I do understand that the money that feeds the fund is derived from motor vehicle registration. So if there, for example, if there's a dip or an increase in those fees collected for vehicle registration, that would ultimately affect how much money is in the fund, and that would also be at the determination of the future legislature to see what amounts they would appropriate to the agency.
All right. Well, we've tried to take, my understanding, we've tried to take as much as possible from that fund and give as much as possible to the mayors prior to EPA coming up with their rules and regs, to give it to the mayors directly so they can directly contract for cleanup, right? And so that's what, my understanding, Mr. Mayor, is that that's where that money's coming from. It's the same source. And so I'm concerned that we will be directly impeding your ability to clean up currently. But, you know, under your current contracts, one of the earlier testimonies was that, you know, harm to our reputation might impede our ability to pay our current contractors, but it's this money that is allowing us to pay our current contractors. That's my understanding. It's this recycling revolving fund. And I just want to find out from EPA again, does, when you said this is waste that we will never have to deal with on our island again, but I thought Chamorro Trust said the waste was being transferred to their property and that a lot of it is still there and it hasn't been cleaned up. What is the status of that? I also understood that there was some notice of violation for that waste. What's the status of the notice of violation?
There is some cleanup that does need to occur, and the agency has every intention of making sure that the property is properly remediated. So if it's a matter of reminding or reissuing a notice of violation to the company, then that's something that we will absolutely do. I think there may be a provision in there about, in the bill rather, about cleanup costs of $300,000 being held in trust in the first FY. So we intend to fully see that the company makes good on the cleanup, and we will hold them to that notice of violation.
How old is that notice?
I don't have that information with me at the moment, ma'am.
It's yeah, I'm curious. I would like a reporting of that if you could, please, or an accounting of it. Just when was the notice issued, and what follow-up efforts have occurred since then? My understanding is it's been years, and I don't know. It's not clear to me EPA's why they're not pursuing that. Okay, so and then I just wanted to ask. I had sent some questions to the Attorney General's office, and I understand your position on the violation of separation of powers, but I had also asked, so the bill talks about a prior year obligation resulting from 2001 license agreement executed by CLTC for 25,000 metric tons of metallic waste removal from the island of Guam. And so my question to you was, is this a valid prior year obligation? And then in another part of the bill, it refers to an ongoing legally binding contract. And that's another question I have, because all we have is the license between this company and Chamorro Land Trust for use of the property. And as they said, according to their license, they calculate, that pursuant to that, there's a binding obligation for 1 million something. But so that's why this language in this bill about prior year obligation resulting in this higher amount or an ongoing legally binding contract in this higher amount, are those descriptions accurate? Have you reviewed the contract? Okay, let's say this contract, as you say, is to amend it is an executive branch function. So what if the CLTC did agree to amend it and they send it to your office? Is this something they can do? Can they put that kind of an obligation on the government of Guam?
I think if the CLTC decides that it wants to kind of explore this option about whether or not they want to amend this license agreement, which my understanding is that they feel like they don't have that's not their position at this point in time. That's something that we would work on, and that's actually questions that we would work on them with them as to, is there an obligation? Can this be done? We're not at that stage at this point.
All right. And finally, my understanding is that the notice of violation for this company had been sent to the Attorney General's office, and I wanted to find out if you know the status of that.
No, I'm sorry, Madam Speaker. I don't know the status of that. I don't recall this specific notice of violation. I can go back and check on, but I haven't heard about this one specific.
Could you please send us a letter that tells us affirmative whether or not there has been a notice of violation by either CLTC or Guam EPA sent to your office in this case. And I guess that's my only questions right now, Mr. Chair. Thank you.
Okay, Senator San Agustin, you.
Thank you, Mr. Chairman. Being it that the Attorney General's office said that it's inorganic, right? It's what's that, separation of powers, Mr. Spaldo?
That's correct.
What I'm concerned about is that if there's an agreement and EPA acknowledges already that the work was done, I'm just worried as how does the Attorney General office plan on defending the government if this ever went to court? Is it going to be another YTK? I mean, where are we heading? I mean, I just hate to wait until we come up with all the reasons why the Attorney General's office is going to have to go into COTC and says, okay, you had an agreement, yes, okay, EPA acknowledges there's trash. You have the mayor stepping in saying, during the typhoons, we had to move it, and it was the government that obligated this private industry to accept it and move it. Where do we draw the line? EPA, how much do you collect from the Department of Revenue and Tax on the motor vehicle? How much money is obtained every year?
Thank you for the question. It's in the neighborhood of 2.9 million that's appropriated from the legislature. I don't have the figure as far
2.9
out of from the legislature every FY.
And if based on this bill, you were to obligate 590,000, it would be just shy of less than 100,000 to the mayors. And if the mayors are willing to say, pay the bill, because they're the one that puts the trash with the agreement of the governor's office, the EPA would have no problem. Am I correct?
Can I make some clarification,
Yes,
Senator? The island-wide cleanup program that was part of the MOA that was signed between the Mayor's Council and Guam EPA doesn't happen every year, from my understanding. So it would seem that if the legislature decides to appropriate any money and have the Mayor's Council enter into a similar MOA with the agency, it would definitely hinder that that effort. The economic stimulus program for the recyclers would also have some issues as far as turning in, being eligible for that $30 per metric ton that they report to under the program. But so if there is if there's nothing in future fiscal acts that require the agency to enter into this MOA with the Mayor's Council, then that's not an issue that we'd have to deal with. I don't recall the last time there was this island-wide cleanup program outside of 2018 and possibly 2014. So it doesn't appear that this happens every FY.
So basically, we're very lucky that we didn't get hit by the typhoon of Utah, right? Because we would have had a major island-wide cleanup. Who would we turn to if they had to go to you, and the mayors had to make sure that each village were clean? Who would they end up turning to? They would turn to you. You would try to find as much money as you needed, right, to help them, and then the mayors would come to the legislature and say, can you find a way to appropriate? Then we wouldn't be using the excuse or the reasons of inorganic or infringement of separation of powers, because they'd be coming from the governor, correct? That's my concern. The mayors are saying they know that it's a true bill. You're acknowledging it did happen. COTC just has problems with the way the bill is drafted. Maybe basically like what Senator Rodriguez mentioned, maybe just go back to the drawing board and we make sure that we fulfill the AG's concerns. Because I already know the two of you here are comfortable. You just want to get it paid. Make sure it's legally right and binding for EPA. And I know the COTC wants to be protected, but I know exactly as the speaker said, there's still a lot of trash at COTC. I wonder who's going to want to accept any contract. If you can't pay prior years, and the bill, I'm surprised there's no interest and penalties. But anyway, thank you, Mr. Chairman.
Thank you, Senator. Senator Nelson?
I think that what was clarified was that, if I'm wrong, that cocoa recycling still has waste on Chamorro Land Trust land. That's what the speaker was saying. Speaker, correct me if I'm wrong. I think that was being clarified, that cocoa recycling still has waste on Chamorro Land Trust land, and who is going to remove that waste? Mr. Lee, I'm very surprised that that Guam EPA supports the back payment of a proposed debt owed to cocoa recycling. And so I'm just wondering, let me backtrack. Chamorro Land Trust entered into an agreement with cocoa recycling, not Guam EPA, not DPW, Chamorro Land Trust. That was their license agreement in the year 2001. And so I'm trying to connect the dots here, because in order to access the recycling revolving fund, in order for EPA to access the recycling revolving fund, all of the outstanding government debts from prior years must have needed to get paid out in order for it to be, in order for the recycling revolving fund to be utilized through EPA. And so I'm just wondering, how did, if they're claiming, if there's a claim that cocoa recycling did not get paid, how is it that the recycling revolving fund was even activated to be used through EPA? And then secondly, I see in the bill that they said that invoices came through. Perhaps my research team missed the invoices for the amount of waste that was removed and put on those ships, because you remove waste and you ship it to another location. You're getting paid there, and you're getting paid by the government of Guam. So it's a twofold payment. And so I'm wondering, where is the invoice, the exact invoice, to show that these ships move the waste from Guam to whatever location they moved it to? Because like I said, it's a twofold payment. They're getting paid to dump the waste in
Right,
another
from
location.
the commodities, I understand that.
So do they have those invoices? Do you have a count of those invoices?
The agency does not have that.
So how did you come to that conclusion that you would support a back payment of debt if you don't have, what documentation are you going by? What historical facts are you going by to see that that the government truly did not pay this outstanding debt? Are you going by word of mouth, or what is it?
There was a previous public hearing that was held on an earlier iteration of the bill. My understanding is that Mr. Bello was able to provide those. That was my understanding.
I have not. I don't know, not unless my colleagues have received it, but okay. We've been looking
my
for
understanding
this information.
was my apologies.
So you went by the testimony of Mr. Bello through the previous bill that was heard in an earlier public hearing of this term, and that is how you came to the point that this is a true and valid calculation of waste being removed from our island, and then therefore they should remove money from the Mayor's Council that we appropriate in upwards of more than several $1 million to pay back Mr. Bello, but there's no documentation that you have physically seen?
My apologies, Senator. We recently come into some bills of lading on the waste. I didn't realize that at the time, but yes, we do have records. But the point that I wanted to make was that the license agreement was not between Guam EPA and Mr.
Right.
Bello.
It's between Chamorro Land Trust.
Right, but we have been forwarded copies of some invoices and some bills of lading. So if that's something that I can provide to you at a later date, then I'll go ahead and make that available.
And if you say some, what is the amount of the sum of the invoice that you received?
It looks consistent with Mr. Bello's claims about the half of the 50,000 that he claimed. So he's seeking
half.
He's seeking compensation for 25,000 metric tons. So the invoices that we do have in our possession that were provided to us as a courtesy do appear to do indicate that. So we'll send that out to you
Okay.
next week.
So how was EPA able to utilize the recycling revolving fund? Because it's stipulated when it moved from DPW to EPA that all outstanding government debt must be paid before the recycling revolving fund was to be initiated and utilized. How did EPA do that if this debt was still existing?
My understanding might be a little fuzzy, but there was some decision that allowed for that fund to transfer over to EPA, and that was way before my time. So but I do realize that there were some cleanup costs that had to be covered before the fund was transferred over to our authority or our management, however you want to call it.
Okay,
now,
so it's not clear. We'll have to research exactly how we were able to execute this recycling revolving fund under EPA, because RRF falls under EPA. EPA doesn't owe cocoa recycling anything, but we're taking it from that agency to pay what I think is an unknown mistake, because we're unable to verify some facts at this time.
mm-hmm.
And so that's just my thing, is I don't understand. There's a lot of gaps in the sequence of events that occurred. And one of my colleagues said, well, what if it's another lawsuit? Well, this took place in 2001. Why are they waiting now to almost 2019 to state claim? Oh, I'm sorry, 2016 was when this term began, 2017. Why are we waiting only now to seek compensation? And if it is a lawsuit, then if it's this amount of money, I would have definitely sought a lawyer out for a lawsuit. So I'm thinking, what else is there underlying? What documentation will not give it muster to go forward and sue the government? There's something missing here, and I'm just a little bit confused about EPA's testimony, because this is another agency should not be paying for something that we have yet, as a legislative body, have concurred with documentation that suffices for the bill to pass. Thank you.
Thank you, Senator. Are there any other questions or comments? Senator Rodriguez?
Thank you very much, Mr. Chairman. Mr. Chairman, I'm very disappointed at how things have transpired this afternoon. There's questions from this panel from here about this issue, when this is really the third bill that we've tried to address this issue. There was Bill 98, Bill 228, and now Bill 350. And so we've been trying to work very hard to ensure that we get this resolved. I'm disappointed because the Attorney General's client, both of you are not talking to each other. We're doing this because we were told that we have to do it this way. And so we're now here 2 months left into this term, and I don't know where this is going to end up. There was questions about have the amounts been verified, and it's been presented to this committee. Receipts have been presented to this committee. The government has acknowledged it in public hearings that this is work that was done and compensation must be made. And so here we are, after the third bill, 2 months left into this session, and we're still figuring out where are things, where are the documents, where are the justification. It's unconscionable for this government to treat our people this way. There was a question about how much the recycling revolving fund has, and whether this amount of 590 that is being identified in this bill will hinder or will be sufficient. The fiscal note on this bill says from BBMR that this 590 that we're appropriating is sufficient, and that it will not hinder operations of EPA. And so if people want to really know what the facts are, what is involved with this, do your homework. Don't just wait for a public hearing or for this to be on the floor to bring up all these questions, because all of these things have been presented in the public setting. And so, Mr. Chairman, again, I want to thank you very much for, I know that we've repeatedly requested for this hearing to be had. but perhaps a roundtable or meeting with the stakeholders to help us in moving this forward, because I do intend to try as hard as possible to get this on our session agenda before the 34th Guam Legislature ends its term. Thank you, Mr. Chairman.
Thank you very much, Senators Rodriguez. I'm going to go ahead and deem that Bill 350-34 COR has been duly heard, and it will be up to the sponsor to, if necessary, conduct any roundtables with the other stakeholders so that they other appropriate amendments that may be needed is incorporated into the bill to enable it to be reported out of committee. So with that, Bill 350-34 is considered duly heard. The next item on the agenda is Bill number 335-34, introduced by Will Castro. So Senator, go ahead and introduce the bill, please.
Thank you, Mr. Chairman. Bill 335-34, in a nutshell, basically intends to set into motion the opportunity for 2 jurisdictions in the Marianas to participate in some kind of a partnership that would achieve certain types of efficiencies, whether it's operational efficiencies or to improve customer care, strengthen government and cultural ties between the 2 partners. But before I get into the details of the bill, I just want to go ahead and publicly thank Governor Torres, Governor Calvo, for their support of the spirit of the intent of the bill, and also various persons, a couple of my colleagues here in the 34th Guam Legislature, and specifically Representative Sablan, Angel de Bampan, and Ivan Blanco for their cooperation in helping to put together an initial draft, Mr. Chairman. Thank you.
Thank you very much. Signing up to provide testimony is Attorney John Brown. So, Attorney Brown, if you go ahead and present your testimony, please.
Thank you, Mr. Chair. Senators, with respect, Senator Castro, my name is John Brown. I am representing myself. I have made a career, as it were, accidentally, about trying to promote, I advocate for, and I take part in the creation of a principled procurement system of good governance on Guam. And I've done it all for free for several years. So I get calls from people about things, and they know that I'm going to try to, and I've heard about this, and I thought, you know, let's have a look. It's not what it appears to be. All right. So I submitted some written testimony early this morning, like about 4 o'clock. I submitted some supplemental information that I don't know that you got, but I think it would be informative for you to read it if and when you do get it. So on my testimony, this is a bill to authorize the governor to enter into a cooperative agreement with 1 or more regional partners to share or consolidate services for medical referral assistance offices. And the intent and title of this bill, is to reduce or contain Government of Guam expenses, enhance operational efficiencies, improve customer care, and strengthen government and cultural ties with participating partner island communities. Well, who can object to such a laudable sounding effort? Well, anyone who thinks this through should shudder at the likely consequences of this bill, whether they're intended or not. Let me note also that the existing law already provides for coordinating medical appointments and related housing and transportation through mutual engagement of services from local or off-island MOUs and contracts, with specified limitations on the amount that can be spent on administrative overhead and term time limits for the durations of the various contracts and MOUs, and restraints from preferential dealing through not-for-profit organizations. So how does this bill improve on that? What does this give us that we don't already have? I don't see this as an improvement the same way other people might, because this bill radically differs from existing law in that it frees the referral office from the accountability, from the integrity and transparency, and most notably from the competition requirements in the principles and of the purposes of the procurement law. How do I get to that? That's kind of end of the world stuff. Well, it changes the characteristics of the existing procurement MRAO structure of seeking assistance by means of contracts and other forms of agreement with the nebulous but noble sounding term cooperative agreement. To explain, the procurement law applies to expenditures of government funds by a governmental body, which the referral office is, under any contract, which includes all types of territorial agreements, regardless of what they may be called, for the procurement or disposal of supplies or services. This is about rendering services. It therefore applies to existing well-defined framework in the referral law that contemplates contracts, MOUs, and specifically requests for proposals. In contrast to that definition and certainty in the procurement law, the procurement law itself arguably makes an exception to its application to procurement of contracts for a governmental body that is simply complying with the terms and conditions of any cooperative agreement. But there is no definition or other mention of what that is in the procurement law. That is the first and only thing we hear in the whole procurement law and its regulations of the term cooperative agreement. Styling the services meant to be acquired by a bill as a cooperative agreement gives the governor a get-out-of-procurement oversight free card, because a quick reading of this exception is, if you're simply complying with the terms of a cooperative agreement, the procurement law does not apply. Now, I don't believe that argument, but I can see why this bill does not use the terms contract and MOU and all other kinds of agreements, whatever they're called. It uses a specific term that looks like an exception to the procurement law called a cooperative contract, cooperative agreement. Does the legislative body even know what a cooperative agreement is? What does it look like? Who makes it? Are there any limitations on it? Or can it be anything that the government wants it to be? What is it trying to accomplish here, if not a cloak of opaqueness and unaccountability for the provision of services that are already adequately and prudently allowed by law? I urge you to steer very clear from this until you see what exactly is being sought that cannot be had under existing law. It would be better to tweak existing law than open up this Davy Jones locker of procurement immunity. History has shown us that unbridled authority to spend government funds with whomever and for whatever tends to end in financial excess and infidelity and in the people's trust in government. You will not have good governance unless you have good procurement. They go hand in hand. And this takes away the governance of the procurement law. That's what stands between us and a debt-free crisis and people getting cranky with the way we spend their money. The notion, but not generally accepted model of cooperative agreements is usually implemented these days by what are called piggyback agreements. This is accomplished by allowing one jurisdiction to join another jurisdiction that has a base contract that it solicited and negotiated, so this third-party jurisdiction can partake in the benefits and obligations of that contract. That is not the the historic terms are in the comments and the ABA model code. It talks about procurement law says the law and regulation shall not prevent any governmental body from complying with the terms and conditions of a cooperative agreement. Complying with the terms. Not soliciting the terms, not going out and getting the terms. So you have to speak in terms of this as an agreement that fits the definition of a procurement contract, expenditure of funds. But it seems to want to skirt that. And comment elaborates. It says, this does not affect agreements such as when a person gives something to the government and conditions it as to its uses. So they were complying with an agreement that was not procured by the government with an expenditure of government funds. It also would apply to agreements with other governments such as the federal government. This is normally the case when they talk about other agreements. It'd be like GTA or GWA and GPA agreeing to share the acquisition of certain products. One of them may enter into it and the other can order off of that contract. That's what is meant here. Not to enter into an agreement with foreign governments or other jurisdictions, even in the states. There's this piggyback stuff has been overdone, overused, and abused in the states. We find I've been writing a procurement blog for 6 years, and I have instances in there of where this has been used as a vehicle for no bid contracts, for people exceeding their expenditure limits, because once you've signed on to this other contract and you procure the goods, you're subject to whatever that contract entails, including lawsuits and other things. So any idea how government contracts are procured and administered in some of these other island communities in the region? This says island communities in the region. That includes the Philippines. It includes Indonesia. How are those contracts procured? Well, I read a lot of stuff about the way they're procured in the Philippines and Indonesia, and a lot of it is not anything that we would consider above board. And if you enter into this cooperative agreement, you're buying into that. Do you want to be tarred and feathered with that? So this bill exudes confidence that the government will save money with the authorized cooperative agreements. But that's not really what it says. It's a close reading says it's couched. It may reduce or contain. There's no promise of that in here. This is not a certain way to do it. And understand again what a cooperative agreement is. It is a relationship that we would otherwise call a contract because you have two parties to it, and if you don't cooperate, you're not going to have a contract. You're not going to have an agreement. And everybody has to agree on the expenses that are involved. Here, you're going to be you have administrative costs. It's not like you walk away from the administrative costs. If you do, you're going to get taken. We are going to get taken. So there is an agreement that requires ongoing administrative costs. There's no savings in that. The only savings you get in this piggyback, even in the piggyback arrangement, is bulk buying gives you a discount. That's fair enough. But negotiating with one other party is not bulk buying. Bulk buying is when you typically acquire things. In some cases, software and sort of that services. And as a big purchaser, but we're not big purchasers out here. You're going to have to spend the same. If you don't spend the same time, you're going to get taken. We get taken by our own people. We're taken by our own contractors here if we don't watch them very, very carefully. So there's no savings guaranteed here, and the bill doesn't promise any. Cooperative agreements have to be administered. They have to be audited. They have to be a requirement, constant communication between these independent parties you're cooperating with to keep them honest and keep you in the game, make them know that you're observing what's going on. You haven't turned your head and got bored and walked away from it. Yes, there can be sticker price comparisons of low price because we got a lot of bulk. But your costs aren't going to be remarkably less in taking care of that. It's the only cost. So it's not free money. although it's intended by proposed 1104B that the Government of Guam will keep ultimate authority to provide the services it is already authorized to provide, that ultimate authority is not the best authority. Ultimate authority means, well, at the end of the day, we can pull the plug. It's what happens between now and that time when you're so fed up you pull the plug that's usually too late, that's going to cost us. That's where our damages come in. So rather than buy a pig in a poke, I would encourage a close look at what would be done within the existing framework of the law before opening the procurement doors wide open. And finally, I'll make a personal observation. Through my insurance carrier, one time I received some medical care in the PI. This was a few years back. In addition to the airfare paid, I was surprised when I got there that I was picked up at the airport and taken to my hotel. And then I was picked up at my hotel and taken to the hospital. And then I was escorted there from the airport to my hotel, to the medical facilities by somebody from the governor's office who did nothing more than get in the car, get out of the car, say hi, glad you're here, let me know if we can be of any assistance. That's an expensive person. I don't need that. I got ripped off by that at the airport the other night when I came home, and I travel around the world. I take my own bags. I picked them up from the turnstile and brought them out myself. I put them on the curb waiting for a taxi, and a person shoved me aside and said, "I'll help you with that." Put them down in front of the car that had just pulled up. That's all they did. And then they wanted $1 a bag. And when I refused to pay it, they got the taxi driver to pay it. When I got to my house, he said, "Well, that'll be $37. Now I live 2 miles." And he charged me for their services, and I got him ripped off. This is what I felt. This is what made me think, going back to what I was picked up by this guy at the airport. I know it cost him money. I didn't get any benefit out of it, and what a waste of time that is. So I think this is just an extravagance to have this service in the first place. I think that it would be better to give that to health and social services. This is a health and social service, this reference business. They are in that business themselves, and it is not political to them. They have a budget, and they provide, and they know who's sick and by how much, and they know what's better for them than some apparatchik in the governor's office. So I think if you're going to put this on the table, add that to the pot. Thank you.
Thank you very much, Attorney Brown. Senator Castro?
First of all, thank you so much for the input. And, you know, let me just state for the record that with previous legislation that I introduced, one of which is the Marine Conservation Act, it's customary for me to sit around with subject matter experts and discuss it for maybe 2-3 rounds before we actually get to move on it. This is the first time that I've actually dealt from the highest levels of government, jurisdiction to jurisdiction. So just for the record, this was meant to start that conversation, and so I really appreciate your subject matter expertise. And I do appreciate you coming in to explain it, and I appreciate the smiles and the respect you expressed. Other than my Uncle Bob, I've never met a gentleman who used so much sarcasm and euphemisms to drive a point home, but I do need your guidance, and so I have a couple questions just so I'm crystal clear on what it is you're attempting to communicate. I agree with you that there is a need to closely observe the procurement law and to honor the competitive pricing mechanisms in place. So it's a very simple concept, Mr. Brown, and I like, Mr. Chairman, I'm going to ask the Public Health Chairman as well to schedule another hearing, because this is meant to have that discussion. I was hoping it could be later and have members of the administration from the CNMI here to have that fruitful discussion around a roundtable. But I do have a couple questions here. So, I mean, a couple points. I was thinking, and it's a simple concept, the medical referral offices, let's say, in Hawaii, LA, and the Philippines. So both jurisdictions already pay rent. And the idea is simple, that if we can cooperate and collaborate and issue a bid, as an example, through the competitive framework you're suggesting, or that's required by law, that instead of one entity leasing 2,000 square feet and another entity leasing 2,000 square feet, that perhaps this joint procurement of 4,000 square feet could yield a savings of some kind. Even further, although not articulated here, and that's the purpose of introducing this bill at this level, to further articulate that neither jurisdiction would surrender management and control of its operations. So that's the spirit. But my first question, as a matter of fact, the governor of the CNMI is calling, but the first question is, oh no, to be clear, it's important that I state on the second page that it was never my intent, nor is it in the intent of either jurisdiction to operate in the cloak of opaqueness and unaccountability. I'm a teacher, I'm not a procurement expert, so I wouldn't know how to get around all that stuff to set anything up. And for the record, I don't have any business interest in the CNMI, just so everybody's clear on that. So I just wanted to make that clear. I had to Google and ask my staff and other members of the professional community what a Davy Jones locker of procurement immunity is. I mean, I know it's some kind of idiom, but could you explain for the record how that...
Yeah, the Davy Jones tale is there was a pirate who had a chest full of silver and gold and jewels, and it's lying somewhere in the depths, you know. So it's a rich hoard. And in here I'm saying when you step outside of the bounds of the procurement law, you have a rich hoard of immunity that you can't be touched.
Okay, so having heard your explanation, just to be clear, the intent is not to fall within the entrapment of that idiom that you use. So my next question...
Well, can I respond to that?
I should take that, Mr. Chairman. Could I ask? So my next question here is, does this body, I can't speak for the body, but your question, since it's directed to the body and I'm the author of this bill, is does the government even have any idea how government contracts are procured and administered in some of the island communities in the region? I'm not familiar with how the CNMI procures lease space in Hawaii or LA, nor am I even clear how we can forge that or establish a legal framework for us to cooperate, whether it's with the CNMI as another American jurisdiction or the Republic of Palau or any other entity for that matter. So the short answer is no, but hopefully after this hearing, unless you want to respond, you can help me understand that better, and perhaps this is not the right vehicle. So I appreciate that. So the answer to your question is no. There's another question here with respect to, or statement here. I mean, you make reference to foreign parties. I'm not sure if you were referring to, could you explain what foreign parties here in the context of the letter, just provide some clarity for the record, please? So that would be on your last page, your signature page, third paragraph down, beginning with there may be sticker price comparisons, etc., long-distant diplomatic efforts of maintaining the peace between literally foreign parties.
Right. The language of your bill talks about sharing and consolidate services for one or more offices with another jurisdiction. A jurisdiction is a legal entity.
Right.
It's not Guam. It's some other legal entity. Now, so if it's not Guam, it's going to be some other place. You also talk about island partners. Well, there's a lot of islands. You didn't limit this to the CNMI.
That's correct.
So anybody wants, we have a lot of business in the Philippines, and you want to do the business in the Philippines, we can do that. There are other ways of doing this sharing of costs. You gave an example of getting 4,000 square feet and sharing it 50-50 with you can do that with a regular contract, signing a lease, procuring a lease that the other party is happy to share, because you're going to procure a 50% interest as a tenant in common in the lease. There are ways you can do this and comply with the law and still be above board with its requisites of transparency and accountability and competition.
I appreciate that, and I wasn't certain if you're referring to the CNMI as a foreign party. Now, the other reference here, pig in a poke, could you please clarify what you meant by procuring a pig in a poke as it relates to this specific endeavor.
A pig in a poke is something that you wouldn't want to give to your best friend.
That doesn't help me.
Well, can I ask that you just Google it?
I sure will. Yeah, I sure will. It's right up there with the Davy Jones
I
locker.
apologize for my cultural...
Okay, I appreciate that. Mr. Chairman, that concludes my list of questions. But again, I appreciate your input, Mr. Brown, and perhaps we can have a conversation offline about this. And I'd like additional clarity. The intent really is to, and if you say it can be achieved through an existing legal mechanism between Guam and or the CNMI, then that's great. I'd like to work with you, and I'd be glad to withdraw the bill. Also, for the record, the CNMI government has not committed to engaging in any kind of an agreement. Rather, the intent of wanting to cooperate with our government, and I have had conversations with both governors and both members of both houses from both jurisdictions, American jurisdictions, that at least the political will is there to work together and achieve that savings if that's possible. Thank you, Mr. Chairman.
I can accept that, but as I said before, this bill uses a poison word. It uses the word cooperative agreement and never mentions contract, as the existing law does. It never mentions an MOU, as the existing law does. It never mentions the request for proposal, as the existing law does. It goes out on a limb and uses a word that is only a phrase that is only used one time in the procurement law to give it an exception from complying with the law. So I don't know where your office came up with this term, but it certainly wasn't an accident.
Actually, it wasn't, and we weren't under legal advisement either. So I appreciate it, and the intent isn't there. I've seen cooperative agreements in the context of one agency working with a private entity as recognized by the United States government to, as you stated earlier, to procure services or products, and they do have to comply with certain procurement provisions as dictated by the federal government. So again, thank you. And my last question, I'm sorry, I was done until you followed up. Mr. Brown, you reference here General Counsel to Jones and Guerrero.
Yes.
Is the firm of Jones and Guerrero the firm that had asked you to provide this legal opinion or
as I stated in my introduction,
Sure.
I'm here for myself.
Okay, but you have a reference to Jones and Guerrero. I was just wanting to clarify for the record. Thank you.
I have a lot of hats.
Okay, thank you.
So did you want to withdraw the bill?
No, I'd like to invite Mr. Brown and any other member of the public who has interest in clarifying and making it better so that we can move forward as a jurisdiction in collaboration with other jurisdictions. No, I will not pull back in my desire to work with other jurisdictions if it means, and it doesn't have to be the CNMI, but if it means it can advance mutual interests of both our jurisdictions, whether it's to deliver a better service or achieve savings or strengthen our political ties in terms of leveraging our position for greater economic stability. But thank you, Mr. Chairman. The short answer is no.
So I would just, okay, fine. Well, you were the one that mentioned it. Senator Spaldon, do you have any questions? I don't have any questions. I'm going to go ahead and deem that Bill 335-34 has been duly heard, and it will be up to the sponsor to sit down and conduct further roundtable discussions to see how to possibly amend the bill before it gets reported out of committee, and also that it will be up to the sponsor to take care of doing the transcription for the committee report and all. So with that, thank you very much, Mr. Brown, for your participation, and with that, we're going to deem this public hearing as being completed, and we will adjourn. It is now 4:52. This meeting is adjourned.